Good afternoon and welcome to the latest of the MacCormick Fellow Conversations. Today our guest of honour is Professor Martin Loughlin of the Professor of Public Law at the London School of Economics, and he will be discussing his latest work and some aspects of his career with two of us. With me, I'm Neil Walker, Regis Professor of Public Law here at Edinburgh, and my colleague Stephen Tierney, Professor of Constitutional Theory. And we both worked and interacted with Martin over the years, and we've very much enjoyed his time here as a MacCormick Fellow. So can I start by asking that question? What do you mean by the modernist tradition in British public law?
The modernist tradition in British public law is actually an attempt to return me to the circumstances of my academic formation. I was an undergraduate student at the LSE and was brought up in a style of thinking about public law that is unusual. And someone once said that education is starting from a particular position and then going off on a journey and coming back to the place where you started and understanding it for the first time. So I am now trying to go back and understand the significance of that tradition. So I'm working backwards to early 20th century thinking about the modern style of public law. It's an intellectual history that's designed to displace the conventional common law constitutionalist narrative about constitutional history and the role of public law in British discourse.
What led you to this? What led you to this circle, if you like? I mean,
Old age is what led me to the circle, Stephen.
What's wrong with common law?
Yeah.
Well, okay. Now let's go. The whole history of my work has led me back to the beginning, because I started out, for the first 20 years of my academic life, I worked in administrative law. So we look at government as an administrative form. And it was only through working in that tradition for 20 or so years that I encountered a series of puzzles for which the traditional ways of thinking about public law within that modernist tradition were no longer doing their work. And that caused me to engage in a conceptual history of the subject. And having undertaken the conceptual history during the last 20 years, I'm coming back to the beginning and trying to reassess the significance of this tradition from Lasky, Jennings, Robson, Griffith, John Mitchell, who was here at Edinburgh, also part of that tradition, and trying to understand and reassess the significance of their work and to try to understand what the contemporary legacy of that work is.
So what would its defining features be, the modernist tradition?
I think it's probably easier to start with the idea of the peculiarities of the common law. The common law, what is distinctive about the common law is it fails to accept the distinction between public law and private law. Common law means ordinary law applies to all legal questions, whether you're dealing with issues concerning private individual to private individual or government minister to private individual. And the whole of the tradition of the common law is to reject this continental European division into public law and private law. And this continental division between public law and private law is built on a state-society distinction. Society is the sphere of the ordinary everyday life, and it evolves as custom and traditions and practices evolve. The state is conceived to be an institutional apparatus that disciplines society, that regulates conduct, that imposes discipline to promote the common good. That yields, in continental jurisprudence, a distinction between public law and private law. public law deals with the institutions of the state and regulating their conduct with ordinary citizens. Private law is dealing with individuals. And the modernist tradition, to answer the question, the modernist method in public law is saying, with the rise of the positive state from the latter part of the 19th century, we are developing a concept of the state. Maitland, greatest ever English legal historian, says in the beginning of the 20th century, we cannot get by without the concept of the state yet. That is what we're trying to do. The modernists are those who accept the need to bring the state into the configuration of legal thought and to work with the framing of society by the modern state and the legal techniques that are used in order to achieve the purposes of the state, which for them is the promotion of the common good.
Can I ask something, Martin? That it's very much about the modernist tradition in British public law, but in order to do that conceptual work, you moved well beyond the British literature and engaged in the idea of public law and foundations with a continental literature. Would you like to tell us a bit about that intellectual journey that, in a way, brought you back to a better understanding of the state?
Sure. I said I started in administrative law. I work mainly administration as a category doesn't really make much sense. Those who use administrative law and build it around a generic idea of administration tend to view administrative law as judicial control of a generic thing called the administration. Whereas if one treats administration seriously, you have to look at socially constructed fields, whether that's social security or immigration control or planning and environmental regulation or the provision of public services. And that's where I started. I started looking at planning and environmental law as a regulatory instrument regulating urban land development, the changes through urbanization. And then I got caught up in the revolutionary changes through the Thatcherite revolution, the 4 successive terms of a conservative administration that tried to shift the boundary between public and private, to privatize public services, to impose market disciplines on the public services that remained. And I worked through that exercise, and working through it caused me to understand the limitations of the functionalist style, which is a feature of the modernist method. Because if one treats law simply as an instrument to realize particular ends, once the ends change, then the functionalist method remains, and that's not really part of the inheritance of modernism as I understood it. But there were no resources within that instrumentalist method to address these problems brought about by a restructuring of the welfare state. And so when I finished my studies of central local government relations, I viewed that problem as a constitutional problem in microcosm. And because of the changes that had taken place in central local government relations over the previous 15 or 20 years, the whole style of legislation had changed. We were now getting directive legislation, which was highly politicized, and it led to a lot of legalization and legal disputes. And we were getting then a legal frame for constitutional ordering. And I then thought, we can't continue to exist like this without understanding more at a more basic level what the concept of public law means. And that meant examining the concept of public law as part of a tradition of European political legal thought. And so I then, from 2000, I then studied the history of the development of public law as a European discourse in order to try to understand what a British conception of public law might mean. And it was really as a consequence of working through that I developed a particular approach to public law, that public law is not to be conceived as a subset of positive law. That is, we shouldn't divide positive law into the categories of public law and private law. Public law was something much more basic. Positive law is the law made by the authorized lawmaking institutions of the state. Public law is the law that authorizes those institutions to make law. So for public law, I have a very broad conception of public law as secularized natural law. It is public law as political right. And I worked that broader sense of public law through the European discourse. And now I'm in the business of going back to the beginning of the modernist tradition in British public law to try to understand modernist British public law as an elaboration of this concept of political right.
But I think within that, though, I think this is a fascinating project, and in an odd way, it's been more of a European project than a British project. Even though it's partly inspired by an attempt to look at the UK within the European tradition. I'm not saying the UK remains an outlier, but it remains one of the more anomalous cases, within the European tradition. And maybe it might be helpful, I think, for our audience as well to ask the following question: that the way within the European tradition, the kind of transmission belt, so to speak, between public law or jus publicum or law politique and the actual positive law is a written constitution.
Mm-hmm.
The UK doesn't have that as a transmission belt. What's the significance of that absence, the absence of what would be seen as the conventional transmission belt between the pre-positive and the positive conception of public law in the European tradition? The fact that you don't have that, what difference does that make to the British case?
Well, it makes a tremendous difference at one level, for obvious reasons, because the modern conception of a constitution gives us a sense of hierarchy of laws in a formal sense that we don't otherwise have in the British tradition. We just have a series of practices so that the constitution changes as the political processes and practices change. But one of the issues I have been trying to explore to make that a little bit more complicated is the question of what we think a constitution is constitutive of. And too many lawyers make the unreflective assumption that a constitution constitutes the state, whereas that modern type of written constitution cannot be constitutive of the state. It is at best constitutive of the office of government, but actually it is simply regulating a set of political practices that go on and precede the state. And a lot of that problem comes in the Anglophone world because of the status of the American Constitution in American political life. And we English readers therefore assume, as do the Americans, that their constitution has constituted their republic, has constituted their state. Compare that with the French, who had their revolution at the same time, and the French state exists and has continued to exist. The French have an image of themselves as a state and a nation, regardless of the constitutional document. And since 1789, they have had 5 republics, they've had monarchy, they've had dictatorship. The state has continued, the constitutional form has changed radically over that 250-year period.
Well, the first constitution wasn't a roaring success, so.
Nor the second, nor the third.
Yes.
We should not assume that constitutions actually carry constitutive authority. That is a product of an investment of a terrific amount of political capital to make that work.
One interesting, to follow up Neil's point, because in your early work you were very sceptical of people who looked to the American experience and seemed keen to adopt that experience to correct our deficiencies. You've taken a comparative approach and you've gone out and read a continental literature, but your project is entirely different from that American co-option process. Would you like to explain how, in methodology terms, what you're doing with the continental literature is very different from what people in the 80s and 90s were trying to do with the American Constitution?
I think the scholars that were looking to the American Constitution as solutions to our own constitutional problems had a very rationalist approach to the subject. Felt that if they can only just plug in certain techniques, then we would be able to, if not resolve our constitutional problems, at least put them on the right track. And I'm always skeptical of technical solutions to political problems, so I didn't think that that was likely to be very successful. On the reason for looking at the European discourse, first, I think the British state is to be conceived as part of a continuing European political history. The modern nation state is a European construct. It's born of 1,000 years of interminable warfare amongst the empires of the European continent, which have now emerged in the modern era as European nation states. But they've had to fight against monarchy and aristocracy to achieve their republics. The United States has a completely different political history. And so the struggles that we have in terms of the constitution of our state, as distinct from a formal constitution, are as much about the constitution of society, of how we conceive ourselves as a people, and what role monarchy plays, what role either a hereditary aristocracy or a new aristocracy that we've created, modern aristocracy, plays in the conduct of political life. And I think in that respect we are much closer to the Europeans historically than we have to our British brethren across the border.
That's fascinating. Can I push you a little bit more on the written constitution question? Because one might accept all of that and say, okay, so one of the ways in which a certain type of constitutional scholar, a certain type of constitutional thinking has reified our understanding of public law is as something which begins and ends with the positive written constitution, right? And which doesn't take account of this pre-positive conception of the public law. Equally, however, and in a recent article that you've written with Stephen, when you talk about the shibboleth of parliamentary sovereignty, Britain has its own form of reification, where it understands the front and centre of its public law tradition in terms of a very, very centralised idea of parliamentary sovereignty, which is a very different thing from the reification of a written constitution, but maybe in its own way it gets in the way. It provides a kind of restrictive self-understanding of the Constitution and of its history and of its possibilities. I mean, if there's something in that, is that a problem for us today when we're thinking about constitutional futures?
Yes, absolutely. I think the shibboleth of parliamentary sovereignty is a very powerful reification of our sense of a British constitutional history, and a tremendous amount of symbolic capital has gone into building up that notion. One only has to look at the work that Dicey did, not just in constructing a formal legal doctrine of parliamentary sovereignty, but the underlying political sense that unless there was an institution at the centre with untrammeled authority, then we would have weak government, and we certainly couldn't rule an empire, and we actually couldn't rule the British Islands very effectively. So we build in this sense that unless there is that sense of an absolute, in a formal legal sense, an absolute sovereign authority at the centre, then the British state would not hold together. And I think that now is a barrier, a very significant barrier to creative constitutional thinking in contemporary circumstances, but that's big.
But even if historically you think it had a certain rationale and a certain justification.
I could understand exactly what was argued, but back to the modernist tradition, which starts with Lasky. Lasky's first book is a book which was called A Study of Some Problems of Sovereignty, and he spends all of his energy debunking the Austinian, Diceian sense of an absolute sovereign authority, and he wants to make he pursues the argument that a sovereign authority only has the authority that the citizens concede, and that there's nothing absolute about it. It's entirely conditional and qualified, and he's trying to debunk that tradition, bring some fact into alignment with the theory in order to qualify the theory and to develop a much more pluralistic sense of what sovereignty might mean.
Can I ask something following on from that? Martin, using the word pluralistic there, not pluralism, I noticed. But in reference to Neil's work, Neil's done an awful lot on how normative authorities moved beyond the state. And in the Shibboleth paper, there is this broader conception of sovereignty rather than the narrow positivist view. It's a much broader, if you like, demotic conception of sovereignty, the generational as well as the distributive. I find that your work on this idea of sovereignty a very flexible resource to manage current developments. How do you think your conception of sovereignty does speak to the kind of work Neil does, where he's talking about how normative authority has, to some extent, been displaced? Because in the modernist tradition, we still want a vernacular basis for that sovereignty in the UK, but I think your theory is flexible enough to deal with this internationalisation of authority, if you like. How do you think your conception of sovereignty speaks to these broadening normative zones, if you like?
That's a very big question.
I know it's a big
but let me try to address it this way.
No one ever wants to say they're inflexible.
I'm inflexible. Let me address it this way. The Diceian tradition, if I can call it that, but it's much of a lot of people buy into it, even though they would not think of themselves as followers of Dicey. But that Diceian tradition starts with an assumption of the autonomy of law. And what is significant about my approach, and which is also a feature, I would argue, of the modernist method, is that it doesn't start with the autonomy of law, it starts with the autonomy of the political. And the political is a distinctive way of looking at the world. And it's a way in which we conceive the entire world as a bundle of groups that are territorially bounded, that have a ruling authority, and they conceive themselves as a people, a nation, a state. And that governs, that sense of political ordering governs the way in which we think about law in the modern world. Because in order to maintain the authority of that way of thinking of a group, a territory, a people, a ruling authority, we have to build up an institutional apparatus that reflects collective decision-making through that group. And that's law. Law has a relative autonomy, but it's derivative of the autonomy of the political way of looking at the world. And when that means that when we hit fundamental political questions, the legal loses its autonomy. It's subservient to a political understanding of the world. And now, how does that help you with respect to pluralism? Well, first one has to draw a distinction between state and sovereignty, because, I was going to say state and sovereignty one level and government at another. Government is empirical, state and sovereignty are conceptual. Sovereignty today is not about the identification of some entity at the center that commands absolute authority. Sovereignty is simply a representation of the autonomy of the institutional framework that has been established to give expression to that autonomous way of looking at the world politically. So sovereignty is an idea, and it's a set of relations, institutional relations. Now, one can disperse the institutions of government as an explication of sovereignty. It's not limiting sovereignty, it's not a constraint on sovereignty, and it's actually an explication of the workings of sovereignty in the contemporary world. So I have no problem with plurality of institutional orders. Federal structures are explications of sovereignty. I have no problem with states sharing governmental power with other states for the purposes of benefiting their citizens. That's an explication of sovereignty, not a limitation on sovereignty. So when the European Court of Justice will say in a case like Van Hendon Laos that this is a new legal order for the benefit of which states have restricted their sovereign rights, it doesn't mean sovereignty, it simply means for the benefit of which states have shared their governmental competences. It doesn't touch on sovereignty in my image of sovereignty. So one can have an extensive degree of plurality of legal institutional orders, but that doesn't touch on sovereignty, and nor does it touch on the heuristic idea of the state, because the state is not a thing. The state is an ontological category. It's that which we have to think about in order to give us access to the way of the political way of thinking about a territory, a people, a set of ruling institutions.
Can I come back there very quickly? One thing somebody might say in response to that, though, is...
Not you.
Someone like me. That when you talk about the distinction between the empirical and the conceptual, another way of thinking about that distinction is between the empirical, the phenomenal, and also the kind of framing imagination behind the whole thing. And you've actually written about the constitutional imagination, etc. So, and I accept that distinction, but then it becomes difficult when you say, for example, that the court in Van Hendenloth's talked about sovereign rights, but they misconceived what they were talking about. Right? Okay. Well, that's their imagination. That's their way.
I don't think the court misunderstood. It's just the academic interpreters who
Well,
think that isn't.
well, that's too easy an answer. I think some of them thought they were splitting the sovereignty atom. I think some of them did.
Exactly.
Either you say that's just a category error and that's just bizarre and it's just wrong, or it's someone else's exercise in imagination. Right?
Yeah.
And it's a different exercise in imagination than the one that you find most plausible.
It's not just that I find it most plausible. What I am trying to do is to say, here are the conditions of speaking coherently about public law in the modern world. If you're using sovereignty in a different way, I don't think you're speaking coherently. If you say sovereignty can be limited, qualified, pluralized, then you're talking nonsense.
Okay, but to say that it's to replace the language of plausibility with the language of coherence is just to really reinforce my point.
Okay.
Which is, but for example, some people let's take a more a better example, federalism. Right. Mm-hmm. Some people see federalism in the same way as you do, as a project for thinking about government, a project which is precisely predicated upon making this distinction between the political and the legal. You can have different legal spheres of authority, but within the overarching political sphere of the state, etc. That's a very reductive explanation. But other people will say, well, the federal idea actually predates the state. There's more to it in the state. Steve is writing a book about the federal idea at the moment, and often I have a book over there which is talking about the European Union as a federal experiment. Saying we're not going to let these statists, have the monopoly of the imagination of the federal idea. And in this other imagination of the federal idea, there is a division and splitting not just of legal power, but of political power. Right? So what I'm saying is that at the very least, maybe, and I think this is one of the debates that we've had over the years, there has to be some kind of, I think, concession that at the margins, just as the modern world wasn't made fully formed in one day, but it came from all these different aspects, including notions which were like sovereignty and federalism, which were brought from other sorts of discourses. Maybe at the end of modernity or at the late point of modernity, you see a fragmenting, you see a fracturing, you see some of these other ideas coming out, and it's not necessarily they aren't necessarily nonsense. They are other ways of conceiving of. Let's find a neutral term, authority, or something like that.
I accept that. As I say over and over again, when I elaborated the idea of public law, when I try to explain the modern discourse of public law, I did not feel as though I was engaged in a thickly normative project. I wasn't trying to say this is how it ought to be. I was trying to unpack a modern practice that had evolved over 300 years of European discourse, which gave us a sophisticated language through which to talk about these questions of political power and political authority in these institutional forms. And what I conceive my project has been is to explain the richness and the coherence of the vocabulary and the grammar of that modern conception of public law. Now, I recognize, and so I'm not saying this is of universal significance. I mean, I'm a historicist. In this field, everything is a product of its history. I accept that we are in a world where the modern discourse is losing some of its authority because the encasement within the modern nation state is in question. And so I accept that there's fragmentation and confusion, and that we might well be in a transitional phase to something else. I'm not saying that's wrong. I'm just trying to say that less so now, but certainly 10 or 20 years ago, we got a lot of cosmopolitan global scholars who were trying to say we hadn't made the paradigm shift. And in making that argument, I felt they were presenting the modern discourse in a less sophisticated manner than it actually deserved to be presented as, and it's much more flexible and than some of the gung-ho cosmopolitans thought about it. And all I was trying to do was say, here is what our discourse means. If you're trying to make the paradigm shift, your obligation is to provide us with a coherent vocabulary in order to explain how we understand political authority in the world today. No one has yet done that. They might have intimated towards it, but it hasn't been achieved. So maybe we are in this region of fragmentation and pluralism, but that's an empirical, conceptual issue for today. But it's not really what my project was really about.
To bring us maybe back round then to what you're talking about today, it's kind of two-part question. I hope it's not opening things out too much. But is the modernist tradition of British constitutionalism the same as the bigger modern project that you talk about, sort of modernism as a 17th century onwards project? And even if they don't map onto each other, is the modernist tradition of British public law, does that still provide us with the analytical resources to understand today's constitution? Do you think that's the modernist tradition of British public law is the best resource with which we can understand the constitution today?
That's a good question, but two parts, as you say. I read, and I'm still engaged in this exercise, so I haven't worked it through thoroughly, but I read the modernist method in British public law as an attempt to connect and engage with the European discourse. And certainly if one looks at the jurist who, I say jurist even though he is a professor of political science, the jurist who does most to try to create the intellectual framework of modernism, Harold Lasky, he is intimately immersed in especially French history and French discourse. And we can see he's seeking to bring the sophistication of that continental discourse into a British framing of understanding. Now, the second part of the question is, what does this tell us about where we're at today? Well, the way the modernist method unfolded in the British discourse, it hit the buffers as a result of Thatcherism and the changing characterization of what the state is and does as an institutional apparatus, that is, and that has posed a crisis for modernist thinking. What I'm trying to do is to see whether it can be reconstructed to retrieve something today from that modernist tradition, but I haven't got that far yet. So
we look forward to hearing more about that.
That's
for a later date.
Yeah, I mean, Martin Loughlin almost 30 years ago made a big splash in public law thinking with his book Public Law and Political Theory, and which on one view, apart from your little book on the British Constitution, was the last book you wrote which was exclusively about the British Constitution, also the one on local government. Since then, he's gone, I'm going to say he's gone cosmopolitan, but
continental.
With the idea of public law and foundations of public law, he has broadened his horizon. So, I see what you're doing today in our talk and in the book that you're preparing as a return to these fundamental questions. So this is, I think we all look forward to Loughlin Mark II on the British Constitution and on the Modernist tradition. So thank you very much for talking to us today.
Thank you.